All right, let's speak to Lesiba Thobakgale, South African Policing Union National Spokesperson, for more. Very good evening to you, sir. Thanks so very much for joining us here on SABC News.
Thank you for having us tonight.
You're most welcome. All right, we've already kind of heard from the South African Policing Union, of course, as the national spokesperson, just in terms of re-emphasizing what was said in the clip by your representative there, that you, as the South African Policing Union, express concern on the constitutionality of the bill. Let's talk about which aspects of the bill you seem to believe would have, issue in terms of the Constitution.
Okay, thank you indeed for having us.
Sure.
From our side, fortunately we were there. We submitted our submissions orally as well today in Parliament and also in writing. There's quite a lot of aspects that we are looking at to say that they need to be looked into, which are quite critical. The issue of the certification thereof, to say when we look at the Chief State Law Advisor, that did not pass that, it did not go through that part before it could even be tabled before the Portfolio Committee. That is a question that we have raised. And moreover, we have touched around Section 8 of the Act, which touches around the vetting. As we know, public servants in most cases, they need to be vetted when they occupy positions. Then you find that the current setup now, you find that some, they get appointed into those positions and they are not vetted, and it takes quite a long time. But what we like to see in the Act is for it to give specific timeframes to say at least within a period of 6 months after the appointment, that vetting should be done. If it is not done, then to look at what recourse could be done, not for it to be left alone as it is, because then it leaves out for more people. You find that you've got people who are not vetted, and at a later stage, there are a whole lot of issues that have been picked up there. We also touched on Section 23 of the Act, which touches about the conditions of service, which leaves the Minister of Police to determine the conditions of service of the members of the IPID. When we compare the salary scales and how they get paid, investigator in IPID, then you find that they then happen to equal to those who are within the South African Police Services, whom they themselves, they are subjected to the issues of collective bargaining. And the input we are giving there, SAPU, is that why can't we also have IPID as well to form part of collective bargaining, so that their conditions of service are not only being left to the minister to make such a determination, because they happen to lose out on a whole lot of issues, more especially when it comes to a whole lot of benefits that they're supposed to be enjoying themselves, as if they happen to be falling under the scope of collective bargaining thereof. And also we touch on Section 30. Specifically when it comes to the recommendations, because there is a proposal that is saying that for the station commander, giving an example, for them to go and institute disciplinary steps against the member, they should wait for the report, a final report coming from IPID. That on its own, it is conflicting with what the disciplinary regulations of 2016 are saying, the provisions there, which says that discipline is a line management function. And if then it is then being subjected to what appears out of the report that is being made, that on its own, it will really take responsibilities from managers who are supposed to make sure that discipline is being dealt with as soon as possible, so that it could be cleared, there are no backlogs and so on. And it also affects when it comes to issues that relates to criminal cases. So we are also of the view that it should not be a Chapter 9 institution. Why should we reinvent the wheel? Because already IPID has its own independence. Some issues that are laying within IPID, they need to be dealt with, mostly which are administrative in nature.
Yeah. And, I'm looking at two different opposing views here. There's a view that, the bill would perhaps create a situation where IPID is indeed more independent, and that it would be able to hold SAPs more accountable. I'll come to what you think about that. But there's also this view that the proposed changes to the IPID Act would increase the oversight body's vulnerability to political interference and manipulation. But, because of the fact that you're so closely linked with SAPS, I want to ask, are you of the view that SAPS currently are not fully accountable, that there would be this particular need to have a situation where SAPS are being held more accountable by changes to an act?
The challenges that has to do with how IPID is functioning, it is not a legislative challenge, more especially when it comes to issues of discipline in nature, as they have been referred to. IPID on its own, you find that it is understaffed, it is underfunded. Those are the challenges that needs to be dealt with. It needs to be given more budget. There need to be more investigators that are hired to work within the IPID space, so that their level of investigation, if capacity is being increased, then it means that their turnaround time will then change, and then it will be sped up. That is what is needed to be dealt with. It does not need a legislative amendment, because if you have such challenges, if you can conflate such with a legislative amendment, you're not going to address the main core. That is the challenge. Even if you can give any form of other independence, which we do not know what that independence would be, because that will just be reinventing the wheel that is already independent in its nature. Because anyway, it is the Minister of Police who then appoint the head of IPID.
And so talking about that, you know what, Mr. Thobakgale, I actually want to go there. This issue of the fact that it seems to give the police minister more power. Some are saying that the bill is unlikely to build a trust. And I guess this goes back to what you're saying, that it's not necessarily a legislative issue. And some are saying that it proposes a sort of weakening of the provisions for appointing IPID executive director by excluding Parliament, and then centralizing this control over the process in the hands of the police minister. I mean, that is essentially the view that has been given, and it seems that is the reality of what the bill is trying to achieve. What is your view on that? I mean, since you also raised it, the fact that it does essentially seem to give the minister more power.
Our view when it comes to that is that currently, when it comes to the appointment of the IPID head, it is correctly placed. We don't believe as SAPU that section needs to be amended for it to go through, or maybe to take it and make it a Chapter 9 institution, where now it will go through Parliament for the appointment of the director and so on, when it comes to that appointment, which currently it is set up under the powers of the minister. Because this IPID in its nature, it is there to police the police on its own. I mean, in terms of what the Act is saying. So we don't think that it should be changed. It should be taken anywhere else, because currently it is the minister who's making that appointment. And still, even after the minister has made that appointment, it doesn't mean that the IPID head now has any form of to allow any political interference or to hear from the minister in terms of how they're supposed to function. The Act on its own is giving the head clearly, or the director, to say, this is what you should follow, this is what you need to do, without fear nor favor. So we don't think that it being taken out from the hands of the minister or out of the police in this case, it will really assist us. Let us deal with the core issues, the main challenges, mostly which are administrative in nature. We take note of what happened in 2019, where now the court now had issues that they then rescinded the decision that was made by the minister at that time. But that on its own, it doesn't mean that each and every minister, when they appoint, then and even when they would fire, then it means that they would always make wrong decisions. So we cannot just take one case and conclude from it. But the director of IPID should clearly know their powers and clearly exercise their independence, being empowered by the current Act when it comes to those powers and what is it that is expected out of them. But reinventing the wheel is not going to assist us. Let IPID be capacitated with with what it needs to do. Let us resolve some of these issues that we have raised from Section 8, Section 23, Section 30, and even others, so that we could improve but not totally to take it out and say, no, it must be a Chapter 9 institution. It's not going to assist us.
All right. Thank you very much. Well understood. That's Lesiba Thobakgale, South African Policing Union National Spokesperson. They're talking to us about the big question that's being raised, whether or not the Independent Police Investigative Directorate should become a Chapter 9 institution. And of course, on their side, they're saying no, it shouldn't.